Hello, and thank you for joining us. My name is Gerald Newman, and I'm the director of the Human Rights Program here at Harvard Law School. Today, we're happy to be celebrating the publication of an important new book called Impeachment in a Global Context: Law, Politics, and Comparative Practice. It's edited by Chris Monahan, Matthew Flinders, and Aziz Huq, and published by Routledge this week. The book looks at impeachment in a global comparative perspective through the lenses of democracy, human rights, and the rule of law. It includes specific chapters on a wide range of countries or regions and overview chapters using historical, legal, and political science methodologies. We are very fortunate to have three leading experts who wrote for the book on today's panel, including two of the editors. After they speak, we will turn to question and answer, and I encourage members of the audience to submit questions using the Q&A function on Zoom. To introduce the panel, Chris Monahan, who will speak first, is principal lecturer in law at the University of Worcester. He's recently published Accountability, Impeachment, and the Constitution: The Case for a Modernized Process in the United Kingdom. He's previously written on the impeachment of Warren Hastings and publishes on constitutional law, accountability, and the litigation surrounding the Chagos Islands. Imelda Dainla is senior lecturer at the School of Law, University of New England in Australia. She has published extensively on the rule of law and democracy in ASEAN countries and judicial politics, women judges, and hybrid justice in the Philippines. She currently works on research projects on crime, punitiveness, and electoral violence, and on misinformation and democracy. She obtained her doctorate and master's degrees in law at the University of New South Wales in Australia. Aziz Huq is the Frank and Bernice Greenberg Professor of Law, University of Chicago Law School. His books include The Collapse of Constitutional Remedies, How to Save a Constitutional Democracy, and The Rule of Law, a very short introduction, forthcoming this year. His research focuses on U.S. and comparative constitutional law. Now, I want to be careful not to praise the book as a whole too much because I wrote one of the chapters myself. My own chapter argues that impeachment, meaning legislative removal of government officials for abuse of office, can be either a cure for human rights violations or a cause of human rights violations. Impeachment normally requires a finding that the accused official has committed constitutional violations or criminal acts, and these wrongs often amount to human rights violations. However, legislators can also abuse the power to impeach in a power struggle between parties or factions without respecting the proper procedures or the required standard of conduct. We had a glimpse of that this week in the farce in the United States House of Representatives, although it failed by a single vote. Abuse of the impeachment power can also threaten judicial independence, as I think we will hear later on the panel. But at times, impeachment may be necessary to protect democracy, as for example in Peru under Fujimori, and as the impeachment proceedings against Donald Trump tried to do. I'd like to thank the American Constitution Society for co-sponsoring this event. I'd like to mention that a Zoom email will come to the attendees after the panel is over with a discount coupon for attendees who wish to purchase the book. And finally, that the recording that's being made of this panel will be posted on the Human Rights Program's YouTube channel a few days after the panel is complete. Thank you, and I turn the word over to Chris Monahan. Please unmute, Chris.
Thank you very much, Professor Newman. And I'd like to say, on behalf of myself and my fellow editors, thank you very much to yourself, your colleagues, and Harvard's Human Rights Program for hosting and organizing today's book launch. Uh, the first thing I would really like to say is it's quite an endeavor to put together an edited collection looking at the use of impeachment around the globe. We were incredibly fortunate to have assembled a fantastic team of contributors who were willing to write chapters on different jurisdictions, to engage in key questions about accountability and the use of impeachment, and to work with Aziz, Matt, and myself during the editorial process. So I absolutely loved working on this project, and an absolutely large part of enjoying the project was having a fantastic team of people to work with. So I know quite a few of our contributors are here in the audience, so I would like to say thank you very much. Now, what we were hoping to do in terms of the book, Impeachment in a Global Context, was to map the use of impeachment around the world and to see how impeachment had been used in different contexts. So the first part of the book was designed to look at human rights from a rule of law, a democracy, and a human rights perspective. The second part of the book was then designed to look at countries where impeachment had been used quite frequently or quite notably. So we had contributions from the United States, where, as you mentioned, the two previous impeachments of President Donald Trump, and also the Philippines as well. We then also were able to look at, with our contributor, John Poga Himikoff, looking at Latin America, then also looking at Brazil as well, and then finally looking at impeachment in countries where it has been used maybe with less frequency, but nonetheless very importantly. So within a European context, impeachment has been used a few times recently. So within the case of Denmark, impeachment has had a second revival since its use in the mid 1990s. And what's really interesting in terms of the use of impeachment in Denmark and then in Iceland against the former prime minister was that these impeachment proceedings could be challenged before the European Court of Human Rights on grounds that the impeachment proceedings violated the right to a fair trial under Article 6 of the European Convention on Human Rights and Article 7. And it's really interesting from a human rights perspective to see how impeachment proceedings were fared in the Nordic model as to how it worked in terms of human rights, and whether the impeachment proceedings involving a hybrid court between lay and judicial members could actually protect the defendant's human rights. And so in the case of both Denmark and Iceland, the European Court of Human Rights ruled that it was human rights compatible. We're also very fortunate as well to have contributions covering the Philippines. So my colleague Imelda will be talking about her chapter later, but also Sri Lanka with the impeachment of the then Chief Justice of Sri Lanka. And that was written by Jeffrey Robertson and King's Counsel. And that really goes to the importance of judicial independence and how impeachment could be used to undermine this. And we also had chapters looking at Central and Eastern Europe. So Philip Kocher looking at how it was used quite recently following the collapse of the Soviet Union. We've got a fantastic contribution about impeachment in Nigeria, and then also looking at the politics of impeachment in Pakistan. The real task really was to try and identify areas and countries that we could actually focus on to ensure a geographical spread, and something which would actually add something new to the literature. As Gerald stated, my own research is on impeachment. I undertook a PhD looking at whether impeachment could be revived again in the United Kingdom, and that's a topic that my own chapter within this book looked at. So impeachment was developed by the Good Parliament in 1376 in England, whereby the Commons, the House of Commons, before it became known the House of Commons, proceeded to actually bring proceedings against key officials working for the then King Edward III. The first person to be impeached was Lord Latimer. And the real achievement of the Commons was to actually convince the Lords to try them. And the Lords, in agreeing to actually try Latimer and others, did insist that there must be proper procedures. So you have a degree of legality, the right for the accused to actually put forward a defence. And that was incredibly important for how we understand impeachment. So impeachment in the United Kingdom has not been used since 1806. The last person being impeached was Henry Dundas, Viscount Melville, a key figure in William Pitt the Younger's government. Melville was acquitted by the House of Lords, and impeachment has not been used since. There was an attempt in 2004 by a group of parliamentarians, including Boris Johnson, to impeach the then Prime Minister, Sir Tony Blair. This impeachment proceedings, supported by just over 20 MPs, got nowhere, but nonetheless, it was an important example of how impeachment could be used. My own research and my chapter in the book looked at, could impeachment be used again in the United Kingdom? Now, impeachment still remains technically available. So the current Prime Minister, Rishi Sunak, could be impeached, or could any of his ministers. But if Rishi Sunak were to be impeached, then the power to impeach him would belong to the House of Commons. And under our present parliamentary rules and procedures as they stand, he would then be tried by the House of Lords in a trial presided over by the Lord Chancellor. Now, that's not really in the UK a ready option. Firstly, because the House of Lords in the UK has got a reputation for being very undemocratic, notwithstanding the Labour Party's reforms in 1999, which removed most of the hereditary peers from the House of Lords. But the House of Lords in the UK is undemocratic. No members are elected in our second chamber. Most members are appointed as life peers. We have 26 bishops and about 92 hereditary peers who are in the House of Lords for good measure, which include the Duke of Norfolk, who planned the King's coronation and the late Queen's funeral. So what I was looking at is, could impeachment serve a purpose in the UK again? And if so, what would be the procedure? What would be the point of impeachment, and what would be its procedure? So within the chapter, I put forward the case for an impeachment act, which would draw upon the use of impeachment in Denmark and Iceland to establish a court of impeachment, which would remove the House of Lords from trying the impeachment, and to actually then draw in the support for impeachment from the European Court of Human Rights to address the rule of law concerns, but also human rights concerns as well. And what I wanted to do was to try and look at impeachment as a form of accountability in terms of ensuring the observance of constitutional norms within the United Kingdom. The UK doesn't have a codified constitution, hence sometimes it's quite difficult to actually enforce constitutional norms and the expectations of ministers under the Constitution. So therefore, if we could see impeachment as a way to empower the House of Commons to buttress existing accountability measures to empower MPs to become guardians of the Constitution. In that way, MPs could bring impeachment proceedings against ministers of the Crown for, in effect, not upholding the Constitution, violating the rule of law. What would be very important would be to actually ditch, in the sense, the terminology of high crimes and misdemeanors, to really focus on impeachment as looking at ministerial conduct with regards to office and the Constitution. And in the event that a minister is found to have to actually have violated this, to look at removal and disqualification. Unlike Denmark and Iceland, not to actually impose a custodial sentence. So really to try and distinguish impeachment from the role of the ordinary courts, leaving criminal prosecution to the courts, and impeachment really focusing on the issue of conduct in office and observance of the Constitution. So that's what my chapter looked at, and it draws into my wider research, and it is controversial in the sense that impeachment has not been used in well over 200 years. Impeachment in the UK, or when we talk about impeachment, the first thing we'd always talk about would be Donald Trump, Bill Clinton, and then if we go a bit further back, Warren Hastings. So the penultimate impeachment trial in UK history was that of Warren Hastings, and the trial lasted 7 years before the House of Lords. So it's got a very controversial reputation in the UK, but nonetheless, if you're willing to look at the advantages of impeachment and draw upon other jurisdictions that enjoy a parliamentary system of government, such as Denmark, such as Iceland, one can kind of see benefits that could be brought into the UK. So that is what my chapter looked at, Jerry. And I think that reveals actually the importance of the comparative perspective, why this book is so, I think, so important, because what our contributors do is, by looking at particular themes, the rule of law, human rights, democracy, as well as particular jurisdictions, it means that the reader can actually then see how different jurisdictions work with regards to impeachment, what impeachment means in these different countries, and how it operates. And I think that's a very important tool for scholars, as well as for students as well, who want to understand the relationship between impeachment and accountability.
Thank you, Chris. Can I turn next to Imelda? You're not unmuted yet.
Okay. Yep. I'm here. Good morning, everyone. But perhaps I should say good afternoon and good evening, as we come from different time zones. First of all, I would like to thank the editors of this very important volume, in particular Chris, whom I have corresponded during the pandemic, but as well as to the Harvard Human Rights Program for graciously hosting this book launch. The launch today, 8 February in the United States, actually it's 9 here in Australia, is a particularly auspicious day in Philippine history, because on this day, the Philippine 1934 Constitutional Convention finished its work and submitted the draft of a Philippine Constitution. So it was also that then former President Corazon Aquino, the first woman president that was installed through the first People Power Revolution in the Philippines, demanded that then former dictator President Ferdinand Marcos concede in a hotly contested elections in 1986. In this brief presentation of our chapter contribution to the edited volume, and may I first acknowledge and thank my co-author, Professor Maria Lulu Reyes from the St. Louis University in Baguio City, who is with us here today. I will highlight only 3 points and leave the rest for discussion. The first is that impeachment in the Philippines is a constant feature of its fluctuating or uneven democratic trajectory. It has been frequently used in the last 30 years. Specifically, it has become a strategic legal and political tool used by contending political elites. Impeachment as an extraordinary legal remedy to exact accountability of abuse of power of the state's highest public offices is present in the 1935 Philippine Constitution and carried over to the current 1987 Philippine Constitution, which was a product of political settlement and public deliberation following the reestablishment of Philippine democracy after the People Power Revolution. However, it became a not so extraordinary process during times of fierce political contest or upheaval, and was deployed to demand accountability or to be used as a political weapon. The impeachment proceeding, which is the focus of the book chapter, is on former Chief Justice Maria Lourdes Sereno, the first woman justice and the youngest justice appointed in the Philippine Supreme Court. Justice Sereno was appointed by then former President Benigno Aquino Jr., who presided over a liberal and reform-minded government. It is the third impeachment proceeding used against a Chief Justice since the adoption of the 1987 Constitution. This leads me to the next point. Chief Justices, the highest judges in the penultimate court, the Supreme Court, have become targeted for impeachment by political actors since 2003 or during the fourth government under the 1987 Constitution, specifically the government of then Gloria Macapagal Arroyo. Our argument in this chapter is that the judiciary, with expansive powers under the democratic constitution, has held the balance of power in times of political crisis and also became the adjudicator of political conflicts, or what is called in the literature as megapolitics. It has become a powerful court known among legal and political circles as the gods of Padre Faura, a reference to where the court sits. As such, individual members have been targeted by political actors for influence as allies or as enemies. Court appointments by the president has become very strategic to ensure policy alignment or acquiescence, and at times this means forging loyalties to the appointing power. This necessarily leads to a divided court unable to forge consensus, and thus makes the court even more vulnerable to both internal and external political pressures or machinations. Thus, when former populist President Rodrigo Duterte came to power in 2016, the court was rife for more strife within and outside. And unlike in previous impeachments of Chief Justices, Justice Sereno's impeachment saw the convergence of the court's institutional fissures as well as Duterte's rampaging illiberal rule and violence that accompanied it. Impeachments were lodged actually a year after assuming office against independent commissions such as the chair of the Commission on Election, the Ombudsman, assault on independent media such as Nobel Prize winner Maria Ressa, Senator Leila de Lima, who was just recently released from indefinite detention. Whether or not Justice Sereno expressed her disagreement with Duterte's flagship program, the War on Drugs, her impeachment became part of what other academics would say as part of an authoritarian playbook. But in the end, that Supreme Court actually as an institution and individually became the key players in the spectacle as they removed their own Chief Justice through a quo warranto proceeding, which is basically an ordinary legal challenge to exclude or remove an office holder from exercising that office. So voting 8-7, the court sustained a legal challenge filed by Duterte's allies, questioning the justice fitness and moral integrity by her failure in the past as a former academic at the state-owned University of the Philippines to file her annual statement of assets and liabilities. This was clearly an action that has not been contemplated in the Constitution and one that lowers the bar for removing high office holders. The uncertainty of the pending impeachment proceeding, which would have been tried by an unsympathetic Senate, led to this unprecedented legal move. The Supreme Court took it upon itself to unlock the barrier towards Sereno's removal. And to make matters worse, as they say, to put a nail in the coffin, The Supreme Court, in response to the motion for reconsideration filed by Chief Justice, was declared to be ineligible to sit with them. And if it wasn't vicious enough, the Supreme Court removed Sereno's name in the list of justices, and her photos is stricken off the walls in the Padre Paura corridor. Let me conclude by saying that Duterte's consolidation of his strongman rule was made quite easy, with the Supreme Court weakened by politicization within and outside, disagreements that turned into personal vendetta, and the need for skillful judicial leadership to navigate messy political terrain and dynastic political elites in the Philippines. Thank you so much, Gerard.
Thank you, Imelda. And Aziz, we turn to you next.
Thank you so much, Professor Newman. And I can say Professor Newman because I first met Jerry when he was Professor Newman and my immigration law teacher. And there was a day when he wrote on the blackboard in big letters, removal is not a punishment, in order to foreclose all of the inevitable arguments by students that people being removed or deported should be accorded the due process that people get in punishment, or in the context of punishment. I feel that impulse that impeachment is not necessarily punishment is a sentiment that might be translated mutatis mutandi to this context. But I learned tremendously from Professor Newman's class then, and I'm tremendously grateful to him for hosting this. And thanks to Chris, who brought me on to the book. The chapter that I contributed to the edited volume tries to place the practice of impeachment in a global perspective using relatively simple empirical data that I collected with my colleague Tom Ginsberg and our co-author David Landau. And I should confess that this is work that appeared in a different form in a law review article a couple of years before the publication of this book. What I'll try and do is break down in about 10 or 12 minutes the core findings in our global study of impeachment. It's helpful to start that summary by placing the topic under consideration, by defining the topic under consideration. In thinking about impeachment, we focused upon regimes that are characterized by the separation of powers, where a regime where the president is legally separate and not dependent upon the upon the legislature. This is in contrast to parliamentary regimes like the United Kingdom, where upon a motion of no confidence, a prime minister, the head of the executive, along with his or her cabinet, can be removed from office. The absence of that kind of dependency as between the branches in the context of presidential systems makes the institution of impeachment particularly important in these contexts. Chris has already explained the role that it could play in a parliamentary context, and therefore worthy of isolated study. Our approach to studying impeachment is to start with the written text of constitutions and, to a lesser extent, statutes that regulate impeachment. It's important to say at the opening that the law, as it's written down, is not going to be the same as the law that is operationalized, that we see working out in practice. And one of the questions that I'll come back to at the end is how best to characterize the law on the ground in relation to the law on the books, what to do with what legal sociologists call the gap problem. Impeachment, though, is primarily a subject for constitution makers. 9 out of 10 constitutions that create a presidential system or a semi-presidential system include some textual specification of impeachment. It's important to say that in that 9/10 of cases, there are important instances where the details of impeachment are filled in through statutes. Brazil is an important case where, as a matter of the constitutional text, the Brazilian legislature has quite broad authority to determine the ways in which impeachment works by enacting statutes. But by and large, impeachment is deemed an important enough topic to address in a constitution. A constitution is going to address a number of different questions about how impeachment is going to work. The first of those, I'm going to talk about a couple of them, is the process question. What is the mechanism through which an impeachment is realized? This is a summary of the steps through which impeachment occurs in the 9/10 of cases that I described. And I think that there's two big takeaways from this table and a small takeaway. The two big takeaways are as follows. First, impeachment is predominantly a process that flows through elected branches of government, and in particular, the legislature. So impeachment is a process that is political in the sense that the predictable incentives of the key decision-making actors are going to be motivated by their electoral standing and their relative absence of buffering, of insulation from political processes. The second point is that impeachment, and this is to a certain extent true whether a constitution channels it through the legislative branch or in the minority of cases channels it through a judicial branch, impeachment tends to be super majoritarian in character. There tends to be something more than a majority rule, either at the proposal stage or at the approval stage. The subsidiary point that I would make is that there are contexts in which other actors play a role. So, for example, courts often play something like a backstopping function with respect to impeachment. For example, in South Korea, courts do and have played an important function determining whether an impeachment is lawful in the sense of falling within the substantive scope of impeachable actions. And in the Latin American context, there's a number of countries which bring in the people in a kind of Bolivarian spirit with plebiscite-like mechanisms tacked on to the end of impeachment. So there's some variety, but principally impeachment is legislative and it's supermajoritarian in character. The second design question that a constitution maker, including impeachment, must face is what the substantive bases for removal of an executive, particularly a chief executive, ought to be. And this, again, is a table that very quickly summarizes the distribution of textual bases for impeachment in the written constitutions we have that are now in force, again, in the presidential and semi-presidential contexts. I would make 2 points about this table again. The first thing is I think we often associate impeachment with criminality of a certain kind. And it's certainly true that a supermajority, but not quite 2/3 of constitutions include crime as a basis for presidential removal. The second point that I would make is that a substantial number of constitutions And I think that we could have done better in this table by explaining how many constitutions fail to do the following. A substantial number of constitutions allow for something other than criminality to serve as a basis for removing a chief executive. So I draw your attention to the category of cases that we call violations of the Constitution. I believe there's language, for example, in the Philippine Constitution that has that form. A violation of a constitution need not be a criminal act. It might be unlawful in the sense of lacking in authorization, but that doesn't mean that it violates the criminal law. So to notice the category of cases, about 1 in every 10, in which something like general dissatisfaction, a sense of unease with the political situation, is an explicit ground for removing an individual from high office. You can put together these two dimensions, the procedural dimension and the substantive dimension, and think about their interaction as producing either more or less rigid species of impeachment. If both the substantive standard and the procedural mechanism make it easy to remove, you have a relatively fluid and open form of impeachment. The opposite result happens if it's both substantively difficult, the class of cases is narrow, and procedurally onerous to remove an official. What we see from this table, which tries to capture how those two dimensions interact, is that most constitutions plump for the Goldilocks solution. They plump for a situation in which the substantive standard is not too onerous, but not too capacious, and where the procedures are demanding, but not too demanding. And I should flag that when I say not too or not too little, what I mean is in comparison to the pool of other ways in which impeachment might be handled that we observe in the world. So all of these judgments are comparative within the pool of observed cases. The final point that I would make about constitutional design with respect to impeachment is that one has to decide what follows from an impeachment. Almost universally, a president, for example, is removed from office. In some instances, there is explicit mention of the possibility of subsequent criminal proceedings. That's not always the case. Constitutions vary dramatically with respect to what the following the ensuing regime is going to look like. So in many instances, new elections are called for, but not all. In some instances, somebody who is a vice president, somebody who in many instances will be an ally of the person who is removed, a co-partisan, is placed into office. And in a surprising number of cases, the text of the Constitution is unclear on this point, which is, I think, is itself interesting because it shows you that sometimes a constitutional designer can focus upon an immediate problem. How do we get rid of a bad apple who's become a president? And fail, perhaps as a consequence of that, to think about the downstream or the questions that follow. Okay. I'm going to go to my last slide. This is my last slide but one, but I'm going to go to my last slide in a second so we have some time for questions. How do these laws on the books translate into practice on the ground? So drawing upon a really terrific earlier study by a group of political scientists back in, I believe it was 2010, Ginsburg, Landau, and I put together data on how many times we see calls for impeachment in the context of legislatures. And this is a graphical representation of how many times you see speeches in parliaments or in legislatures calling for impeachment, how many times you see formal motions being made, and then the underlying rate of removal. I think the key point to be made here is that it is very frequent to see, or more accurately, to hear impeachment talk by the actors who are constitutionally invested with the authority to trigger an impeachment, to legislatures. But in comparison, it is quite rare to see impeachments work out in practice. So there's a big gap between the discourse of impeachment and the actual practice of impeachment. Indeed, we can take that point one step further and isolate the class of cases in which we see impeachment actually occurring. That class of cases is really small. There are hundreds of instances in which impeachment is called for at some point within a legislature, and only about 10 cases in which we actually see an impeachment occurring. A couple of points about this table, and then one concluding remark. So one point about this table is that the dates are relatively late in our times in the time period that we study. So impeachment does appear to be increasing in frequency. And so, as they say in the investing world, past performance perhaps not a guarantee of future profits, right? Maybe we'll see more impeachment in the future. Maybe once something has been tried, it becomes more common to observe. The second observation about the data is that we see impeachment being used repeatedly in different jurisdictions, right? So we see Imelda has talked about impeachment in the Philippines. South Korea has had a number of different impeachments. Brazil has had a number of different impeachments. There seems to be some sense at the national level, and this is, I think, not a crisp result from the data, but more an intuition that the data supports, that once you start impeaching, it is difficult to stop. As Professor Neiman mentioned, you might characterize what's been happening in the United States in those terms. How do we then think about the class of cases in which we actually see impeachment in relation to the substantive law of impeachment? Recall that the substantive law of impeachment covers, in many instances, both acts that are criminal and acts that are violations of the Constitution, or acts that are not criminal but are in some fashion productive of disapproval or opposition on the part of political elites. So there's a broad category of quite heterogeneous substantive grounds for impeachment. Surely there are far more than 10 instances in the past 4 or 5 decades in which one or other of those substantive grounds has been present. Right? There's something selecting, or there's some selection principle that is determining how we go from the very large universe of cases in which impeachment could happen to the very small universe of cases in which impeachment does happen. So our suggestion is that the way to think about that selection problem is to observe that impeachment tends to happen through legislative processes. So and it tends to happen through supermajority vote. So the instances in which an impeachment is successful are instances in which there is cross-party agreement on the necessity for removing a chief executive from the scene. And those tend to be moments at which there is a widely shared sense of political crisis. So in operation, and I should have said, and I'll say now, that what I'm speaking of here is primarily chief executives. So in operation, the impeachment of chief executives seems to work something like the no confidence mechanism that is observed in parliamentary regimes. It seems to work as a mechanism for selecting those instances of removal of a chief executive where there is a broadly shared cross-party sense of political crisis. So what seems to be doing the work in the selection moment, therefore, is not so much the substantive grounds, but the the substantive effects of the procedural mechanisms most commonly associated with impeachment. So I hope that gives a little bit of context, and I hope we have some time for questions.
Thank you, Aziz. I do want to invite questions from the audience. I haven't seen any arrive yet. And while I'm waiting for them to arrive, I'll ask a question or perhaps even two. Can I ask Chris, general question, given what you've learned through the editing of the book, do you have any insights on why impeachment has made a resurgence in some countries in recent years, but not in others? And let me add here that some of this resurgence may not be visible in Aziz's chart because of the cutoff date for Aziz's chart, and some of the resurgence may not be visible in Aziz's chart if it doesn't involve removals of a president in a presidential system or semi-presidential system. With that framing, Chris, is there something that you could share with us from what you've learned in putting together the book?
Thank you, Jerry. I think that's an absolutely important question, actually, because in terms of actually the use of impeachment, looking at removal of heads of looking at heads of state in terms of presidents, there is a parallel with the vote of no confidence measure in parliamentary democracies. What was actually really quite interesting was looking at in terms of countries such as Denmark. Now, Denmark, since about 1904, the Danish Parliament got the right from the Danish monarch to be able to actually instigate a vote of no confidence against the king's ministers. And so under the Danish constitution, there was a right for impeachment, and it was believed by scholars that this vote of no confidence would actually do away with the need for impeachment. However, in the early 1990s, you had the Tamilgate controversy, big constitutional crisis in Denmark, and you had the impeachment of Nin Hassan, the senior justice minister in the Danish government. And that was back within the context of Danish concerns about immigration and the real clash in Danish political culture between the left and the right. And commentators immediately said, oh, that's a one-off. We'd never see impeachment again. And lo and behold, in 2016 and going forward, we have fresh impeachment proceedings. And that's really interesting to see the resurgence in Denmark, notwithstanding the vote of no confidence, but also in the mid-1990s when impeachment took place and a minister was convicted and sentenced to a custodial sentence, or that was commuted due to ill health, that the response was actually, oh, this won't happen again. In terms of Iceland, with the impeachment of Hardy, the Danish Prime Minister, what's quite interesting actually is the kind of sense of buyer's remorse in the Icelandic system about an almost kind of regret for having impeached. And so the former Prime Minister now is I believe the Icelandic ambassador to the United States. And so it's quite interesting to actually see in parliamentary systems, the relationship between impeachment and votes of no confidence. I think in terms of actually looking at the United States, actually, and I think drawing upon what's been said about impeachment, about almost how impeachment, once it's used, starts to continue. I think we can see that in Denmark. Actually, it's getting a lot more attention. So I hope that's gone some way to answering the question. But it was really interesting to actually see the use of impeachment in Europe in parliamentary systems.
Thank you, Chris. Just to clarify, when you were talking about Denmark and the divide over immigration, it's my understanding, tell me if I'm wrong, that the impeachment issue, perhaps to the surprise of US viewers, involved the impeachment of ministers who were insufficiently respectful of the rights of immigrants. And that was what the legislature was upset about. Is that correct?
That is absolutely correct. And with Hansen, the justice minister, it was his refusal to actually comply with the law, which would have allowed families of Tamil asylum seekers from actually being able to join their family members in Denmark. So yeah, it was incredibly politically controversial and a testament really to the coalition system in Denmark, but also trying to balance the kind of Scandinavian approach to asylum with against actually some quite right-wing politics as well. So it's and the 2016 impeachment in Denmark again, that's got to do as well with the backdrop of asylum as well.
Thank you. So I don't have any questions that have come in yet. So I will ask Aziz a question. I'm not sure exactly how to phrase this question to match the wording that Aziz used while speaking. But I think if we talk about a convergence between impeachment and no confidence, one could ask, is there a real tension here between what you're observing and what you're arguing perhaps in favor of? And the argument that I make in my chapter about from a human rights perspective, it's important to police the distinction between impeachment and no confidence. That in a no confidence system, the legislature is free to remove people because it lacks confidence in them for whatever subjective reason, and it doesn't have to point to specific demonstration of wrongdoing. But that in most countries that have an actual impeachment process for a separately elected president, there are standards there, and there needs to be proof of wrongdoing and not merely a preference that this person should be out. What would you say about that possible tension there?
I think I think that there's a number of different competing normative values that are at stake. And I think you're absolutely right, Jerry, to say that the normative values cut in different directions. And depending upon how one weighs them and what the forces are acting on the impeachment mechanisms in a given jurisdiction are, right? And those forces are going to vary from case to case. The normative valence of impeachment in the aggregate in different jurisdictions is going to vary considerably, even if there's not a difference in the textual specification, either if it's procedures or if it's substance. So let me give you a couple of examples or let me point to one value that I think you're right to say is placed into doubt by the descriptive account that I gave of how the law on the ground has come, the law on the ground of impeaching chief executives has come to look a lot like the practice of using no confidence motions. One concern that raises is a kind of rule of law concern, in the sense that the rule of law, in its classic formulations by people like Fuller and Raz, places a premium on clarity and predictability of legal standards, particularly when those legal standards are connected to or triggers for some kind of burdening or detriment being imposed by the state. Here, or what we're observing globally, if our evidence is correct, is that although impeachment remains focused upon criminality, 63% of constitutions use criminality as the index for impeachment. Impeachment has ceased to be closely associated with criminality, and instead has come to be more closely associated with political crisis. So that I do think that is a problem of legality, a slippage between what's stated and what's not stated. So that, or what's stated and what's done. And I do think that there are good reasons for concern there. I don't think that was the normative issue that you were pressing on. I think that you were pressing on the issue that, to the extent we think that impeachment is a form of, or either is itself something that is so onerous that it triggers substantial rights-related concerns, or if we think that, as in the context of the removal of judges and places like, well, in many places, it is an instrument for harming the human rights of third parties, then the decoupling from a criminal standard is problematic, especially given the absence of the presence of a greater risk under the circumstances that I described, that the impeachment mechanism will then be misused. I think that is also correct. I think that is also a real normative concern. I think on the other side of the ledger, I would put two points. The first point is, I'm not sure we should think, as I intimated at the beginning of my remarks, as impeachment as a kind of punishment. I'm not sure we should think of impeachment as a judicial mechanism for allocating responsibility, as opposed to a political mechanism for altering or switching the bodies that control power. And one reason for thinking that is that the primary consequence of impeachment in most regimes is you lose an office. And losing an office, just like losing an office because you've lost an election, I think is not usually thought of as a punishment. It's actually a healthy and appropriate part of democratic life. In the absence of parties losing power and gracefully leaving office, you don't have a functioning democracy. So the primary effect of impeachment is one that I think is better understood as an ordinary feature of democratic politics, rather than as something that we characterize as punishment and place within the judicial sphere. So I think that cuts in the other direction, makes the situation slightly more normatively palatable. And then the other point that I would make is, while it is true that impeachment can be misused for partisan reasons in the way that you describe, one also might tell a story to the effect that once there is a general realization that impeachment is a political mechanism, and it's a political mechanism that really ought to be used under conditions in which there's broad cross-party agreement, that a kind of reboot or fresh start is needed, particularly at the level of the political apex. Once there is an understanding that is what's going on, then it might be that there is a large class of cases in which impeachment is not used in an abusive way, but it is instead used as an instrument for introducing flexibility into a form of political rule, presidentialism, that has been famously and I think rightly critiqued by Juan Lentz and other political scientists for its rigidity and its inflexibility and its incapacity to shift and change over time. So I don't think that there's a simple normative story either one way or the other. I think that I think there are reasons to be worried about the reality on the ground that we see with respect to the use of impeachment, but there are reasons to be optimistic too. Across the universe of cases, in some instances, the reasons for optimism will be powerfully present, and in some instances, the reasons for skepticism and pessimism will be powerfully present. And I think that what we therefore see is a profoundly complex normative picture where it's hard to draw conclusions across the board, but certainly with respect to a given case, you can say the normative conclusions, the normative concerns you raised, or my legality concern really are biting hard. And there are going to be other cases where we might say, well, this is an instance in which we're not really worried about those legality effects or third-party effects, and we think that this is that the political system here was too rigid, and what's being introduced here is something beneficial in terms of flexibility.
Thank you, Aziz. We have come to a little bit beyond the time that we allotted, so I won't try to continue the conversation except to steal a closing word or two. First to say, I want to say I agree with you absolutely that removal from office is not criminal punishment. And I don't disagree with that at all. I think we still have some disagreements about what the proper function of impeachment in presidential systems may be, but that's a conversation that we can have. We've exposed it here, which is a good thing for a panel to do. I want to thank the audience for having been with us. Thank the panelists for a splendid discussion. These are important issues. They don't arise all that often in any particular country, but there's a lot to learn from the experience of other countries, and the book is a wonderful help in letting us think about these issues for when they arise next, wherever we may be. Thank you, and be well.